Hi, I'd like to welcome everyone to today's webinar. I'm Rick Schwartz, one of the partners with Schwartz & Schwartz CPAs, and we'd like to invite you to join us today. Before we begin, I'd like to tell you a little bit about our firm. My brother and I started Schwartz & Schwartz in 1993. It's continued to grow every year. Currently, we're about 20 employees year-round, and we ramp up to about 25 during tax time. One of the things we focused on over the years is just a strong commitment to our clients and to provide excellent service to them. Since our early days, we focused on serving the healthcare professionals, their families, and their practices. We try to offer a comprehensive menu of services to our clients, which include personal tax work, corporate tax work, payroll, and just general accounting services, as well as college and financial planning. Our goal with offering these financial boot camps is to help you become financially fit. And just what is financial fitness? To us, it's being well-informed, making confident choices, and pursuing a solid plan to reach your goals. When deciding who to team up with these sessions, our first choice was First National Corp. We've worked with First National Corp going back close to 20 years now, and one of the things that has brought us together is their superior customer service as well. And their focus on working with clients and helping them meet their financial needs. So at this time, I'd like to introduce Alex Oliver, who will be presenting today. Alex has been with First National Corp for a couple of years, and I'd like to welcome him to the webinar today. Thanks, Alex.
All right, great. Thank you, Rick. Appreciate it. And thanks, everybody, for joining us today and surviving through the snowstorm, getting power back, and joining us for this webinar. We're going to go through our third presentation in the boot camp series. If you haven't been to the ones previously, about 4 weeks ago now, we had one that was the quick and dirty personal finance checkup, which we went through a wide array of areas, very briefly touched upon estate planning. Then a couple of weeks ago, we had a seminar in regards to student loans called The Game of Loans, where we discussed a deep dive on how to handle student loan issues. Now we're going into a deep dive on estate planning, and in a couple of weeks, we'll have another webinar preparing for the rising cost of college. So if you haven't signed up for that one yet, and you have some children that you're saving for and thinking, how the heck am I going to get ready for that, I'd encourage you to go back to the website and get that signed up. But for today, I'm joined by Sean Hagan. I'm going to set the foundation for our estate planning seminar today, and then Sean will start to lay the groundwork as to how to actually implement an estate plan. Just to carry on Rick's introduction of First National Corporation, we're based out of Rockland, Massachusetts, on the South Shore, about 30 minutes south of Boston. We're a registered investment advisor, meaning that we have no affiliations with other mutual fund companies or life insurance companies. We're completely independent, which gives us a position to be a fiduciary, meaning we can act in our clients' best interests. We have two sides to our business, one on the wealth management side, where we work with about 450 individuals and families, managing their investments, getting them to their retirement, saving for college, handling their loans, and obviously getting the start going for their estate plan. The other side of our business is dedicated to retirement plans, such as 401ks or 403bs, or profit sharing plans and cash balance plans. We work with around 50 employers across New England in that capacity. So just a quick disclosure here before we get started on our seminar, which is to make sure you consult your own advisor or state attorney before implementing any strategies that we talk about today. Certainly on this topic, it can be very unique to somebody's situation, and you will find that out as we go along. So we don't want you to take anything that we say today and try to enact it on your own, or try to go online and do this on your own, because there might be dire consequences to that. So please don't take the presentation as personal advice. Okay, so just to lay out what we'll be talking about today. So, as a financial advisor with the families and individuals that I work with, we have, if you've been to our presentations, been touching on several different areas. And so just to be clear, I'm a financial advisor. I'm not an estate attorney, but many times the basis of this conversation starts with me when we're working through an initial financial plan, and I'm going through a risk management assessment to say, do you have your life insurance in place? Do you have your disability insurance in place? Do you have your estate planning documents in place? And if the answer is no, we might start to have some of those conversations, and I'll talk about what that might look like when you're working with an advisor. We'll certainly talk about those key elements to consider. And then again, Sean, on the back half of this presentation, we'll talk about the estate planning tools that we'll end up implementing. So again, I try to serve up and have those conversations in advance, and then certainly use estate attorneys like Sean to implement those strategies. So let's talk about where you may be. So, in this position, I think I continually find myself amazed by how many people have not gone down the path of putting in an estate plan in place, which, can be kind of understand, So I want to just take a minute to discuss why that might be. There are many other areas where people like to put this a topic off, such as saving for retirement or saving for college, or again, putting in the estate plan. So the question is, why? Why have you procrastinated? Because again, across the webinars that we're doing in this bootcamp series, I think this one right here had the most amount registered for it. I think we had upwards of 60 people signed up. So it's very apparent that we know that estate planning is important, which I will go ahead and emphasize here in a moment. But we seem to put it off and don't get the plan in place. And again, very common, if that's you, we understand where you're coming from. Some of the reasons where we may see this is that as you're young, to start off, you might look at yourself and say, well, I really have no estate to actually plan for. I have no assets, maybe I have no house. So if I pass away today, if I even have no dependents, there's really not a big issue there. Maybe that's your mindset. Maybe you have some family issues that you really don't want to weed through at this moment in time. Again, it just kind of presents an awkward position for you. You might perceive that there's either too much complexity or too much cost with putting an estate plan in place. I think we'll address that here today. I think maybe even more importantly, there may be a reluctance to think about yourself either becoming disabled or dying. I mean, I don't think there's many people that have a lot of fun having that conversation. And if you've ever gone through making an estate plan, it can be a little morbid if you actually think about some of the finer details there. So again, that might be a reason why you're putting off this conversation. And then I've actually had this last line said to me a couple of times, which is to say, well, once I'm dead, what do I care? What do I need to put an estate plan in for? I would encourage you to take that last line and really throw it away. I look at the estate plan as being an unselfish act, because at the end of the day, when you pass away or you become disabled, it will be your family and your relatives that have to deal with either distributing your assets or taking care of you or whatnot. So really, this is being put in place in some sense to take care of you, again, if you become disabled, and certainly we'll talk about that, but also to help everybody around you as well. So we're really making a big push today to make sure that if you have not put an estate plan in place, that you know exactly how to do it, why to do it, and we'll go ahead and get it done. Okay, so let's talk about exactly what we're talking about with estate planning. On a most basic level, it's deciding what's going to happen with your assets when you pass away. So whether that be your financial assets, your real estate, your personal property, your retirement plans, or your insurance, we want to make sure that we have decided well in advance where those things may go. Retirement plans, as an example, are kinds of accounts that have beneficiaries designated on them. So we don't have to do an estate plan necessarily for a retirement plan, but we do have to review the beneficiaries as your families change over time, as you have more children or maybe go through divorce, to make sure that's okay. But there are other areas that certainly are not covered by beneficiaries that we'll talk about that we want to make sure is taken care of. And why might we do this? Well, at the end of the day, we want to make sure we take control of our assets. So who are these going to go to? Whether it's my charitable causes that I'm involved in, maybe it's a school that I went to that I want to leave a foundation behind to, or maybe it's just my children that certainly need some assets to get by, especially if they're at a young age and haven't gone through college yet. So these are all, again, major reasons. But these last two reasons are also just more common sense to help allay your fears of putting an investment into an estate plan, which is to minimize probate We'll talk about probate again later, but essentially that is where a court will decide what will happen to your assets for you on your behalf. And then to reduce taxes. When we say reduce taxes, we're talking about estate taxes, which there have been some changes to that on the federal level, but not so many changes on the state level. We're in Massachusetts today, and we'll be talking about that as we go along here. So what happens if you don't put an estate plan in? Well, essentially, we like to say that good old Uncle Sam has a plan for you, and it may be a plan that you don't like. Essentially, a court will decide who these assets are going to go to. Again, they won't decide things like retirement accounts because you'll already have beneficiaries on them. Life insurance, another example where you'll have a beneficiary designated, and that will automatically go to that person. But things like your house, if you owned it individually, any jewelry, any other vacation homes, any other just valuables that you have, collectibles, the probate court is going to have to go through and decide where those people are, who is going to get those things. And I think more often than not, heirs may seem to think that, well, they would have wanted it this way, but they didn't put the estate plan in, and now I'm only left with X. So again, trying to take these steps ahead of time to make sure that you don't fall yourself into that awkward position of fighting with the court of law. Going back to the tax situation that we talked about just recently in December's new tax bill, the estate tax was raised on the federal level. So now we have an exemption level that brings up to $11.2 million for individuals, $22.4 million if you look at it as a married couple. If you happen to be over those levels, you would face a 40% tax rate on anything that was passed to your heirs, or I should say your heirs would end up having 40% less coming to them. But again, that's a great news on this side of things to know that we are not subject to that in many cases. But some may forget that Massachusetts has an estate tax that starts at just $1 million in assets. It works on a sliding scale, so it can start out at 0% and then go all the way up to 16%. And $1 million, may have sounded like a lot of money once upon a time, but in 2018, it certainly does not. If you own a home in the Boston area, you probably already have at least $500,000, if not $1 million in assets in your home. If you have been prudently planning your whole life, you've taken out term life insurance policies when you were young, and that probably was at least $1 million, if not $2 million. And as you've gotten older, you've certainly saved into retirement accounts, which certainly will help you exceed that $1 million mark. So I'd say virtually everybody at some point will face a position in their lives where they're at least dealing with a estate tax, okay? So let's talk about how we're going to end up setting up this plan, what kind of process we'll go through. Again, these are the kind of things that I would do with my client, potentially even before going out to the estate planner, trying to understand a little bit about your family dynamics, whether you're in your first marriage or your fourth marriage, whether you have kids from an earlier marriage versus a more recent one. There are other special situations that we'll talk about, but again, trying to have an idea as to what your situation looks like, getting a plan, and then I'd say around step 4, bringing in somebody like Sean to actually draw up the documents. And then finally, step 5, which is to review those documents. Certainly, there are many changes in the law over the years. If you drew up a trust back in 1995, there's a good chance that that is out of date and maybe no longer valid. Or again, maybe your family situation has changed substantially since that time. So let's start diving into some of the details here of the kind of things that you might want to be thinking about. Certainly, I think most top of mind would be to ensure your spouse's financial security. So when we go back to that estate tax issue, luckily any assets that pass to your spouse you won't have to pay an estate tax on. The surviving spouse may have to once they pass away, but any assets you pass to them will not have an estate tax. So how much money do we want to leave to ensure that that spouse is going to be able to, say, pay off the mortgage or put the kids through college or get through retirement on their own, maybe put in a long-term care plan, maybe long-term care insurance is a part of that plan. Again, making sure that the surviving spouse is going to be okay. Again, providing for children, whether that's everyday needs if they're older, or their education topics if they're a little bit younger. You may have some relatives or friends, nephews or nieces that you want to benefit here. And then, as I mentioned, charities earlier, there are all different ways to do all these kinds of things. So the next step is to really take an inventory of what assets you have. If you work with First National Corporation, we actually set you up on a website similar to mint.com. If you ever use mint.com, it aggregates all of your assets into one place. This wealth management system does the same thing. So, very quickly, if two spouses are able to log on there, if somebody passes away, they can immediately know whether those assets are at Fidelity or Charles Schwab, or if they've got a life insurance policy at Principal. It's all right there and easily accessible, and easily, with your financial advisor, they know where they are, and with a login, your spouse will know where they are. As we're taking that inventory, we want to make sure, again, we know how those assets are titled. So if you own an asset solely, certainly that's going to be something that you may want to put into a trust, which Sean will certainly address here in a minute. If you own it joint rights of survival, as an example, this is a great way to hold a piece of property, because again, that now pushes it right off to that other person that you're going to that you owned it jointly with. So certainly taking account for ownership and evaluating your current net worth, so that way we can ensure that we're avoiding any taxes where necessary. Some special situations I want to talk about. Again, these are just some thoughts that you want to make sure you have before you go and meet with an estate attorney, so that way you can immediately bring these things up and they know what direction to take the conversation in. If you have children from a previous marriage, this would be a great example, because certainly from family to family, this may vary. If my wife's child from a previous marriage, maybe I have a really close relationship with that child. Maybe, I've known them since they were 4 years old. I treat them as my own child. And for my own assets, beyond my 3 children, they're each going to get a third, a third, a third. Or if this is a marriage much later in life, and you're the 20-year-old from my wife, I really have no relationship with at all. And I know potentially that my wife's ex-husband has a significant amount of assets that they're leaving to that child. I might cut that child out of the plan. It may be something that we want to communicate to everybody, but again, just another thought to have as you're blending families here. Certainly, special needs is a huge topic in estate planning. You really want to make sure that you're working with somebody that has had a lot of experience here, to make sure when you're leaving behind assets, it is being left with somebody in charge that will have the best interests in mind of that child. Depending on the disability, depending on how old they are today, will really dictate how that plan is going to go. A business partnership, I think this is a major part of estate planning. If you are in a partnership with one other person, certainly you should be considering things like a buy-sell insurance agreement. So if I die, maybe my partner can buy my portion out, and then that purchase can then go to my heirs. That's usually a really great scenario. A really bad scenario might be, again, not planning at all, and now my 3 children end up picking up the ownership of that business, and now my previous business partner is in partnership with my 3 children. That's probably not going to go so well. So again, just another thing to be thinking about well in advance. How will we handle this situation if you or I pass away in this partnership? And then finally, family heirlooms or collections. Again, we try to make this on a really simple basis. Let's just split up assets, a third, a third, a third to my 3 children. But when it comes to heirlooms, there may be one child who will actually appreciate these things, keep these things. A lot of this comes into, I think, our cultures, where we may come from different countries or just have different, religious aspects to our lives. We want to make sure we're really taking some thought there, and, not leaving our precious collections or heirlooms to the child who's just going to simply go to the pawn shop and get it sold down the road. Part of estate planning is not always thinking about assets, but maybe thinking about how our legacy is going to live on as well. So I would give some careful thought if you have things like that as to who those are going to go to. And if you're leaving one child with a significant amount of collectibles or heirlooms? Maybe they get less of an inheritance from the retirement account. Again, these are all just kind of questions that you're going to want to ask yourself as you start to develop this plan. Okay. And so finally, going into, we've gotten all that information together. Now we're going to talk about just some options that we have and really make sure it's part of the major financial planning side of things, making sure, before we've really decided who these assets are going to go to or what kind of trust they're going to go into, making sure you're taken care of for immediate needs for your financial plan, and then going through the various estate planning areas that we can use to make this work for you. Okay. So with that, I'd like to turn it over to Sean Hagan of Escott Law Group. He'll go ahead and introduce himself, get a little background on you, and really, I think, go through some of these finer details and bring a little clarity to how we might implement a plan for you.
Thanks, Alex. That sounds great. And thanks for the introduction, sort of set the stage there. So a little bit about myself. This is my area of specialty, working with families to draft these and other documents we're going to talk about today. We also do probate and estate administration. So when you actually pass away later in life, dealing with the process and sort of where it picks up. So it's sort of full life cycle on the estate planning front. And we also deal with litigation related to this. So when people either done poor planning or a lack of planning and families are fighting, we represent clients in the family and probate courts here in the Commonwealth and throughout New England on these issues. So the goal is to not have the fighting happen, right? The goal is to be proactive and get these documents set up properly in the first place and to avoid those extra costs and stress. And a little bit about the firm itself. Escott Law Group, it's a boutique firm. Our specialty is dealing with people in the dental and medical industries. And that's full life cycle for those folks as well. So whether someone's just, out of school and they need an associate agreement drafted up, or they're buying or selling a practice, you can see employment matters as they pop up, throughout your practice when you have employees. Oftentimes, as you probably know, real estate is a component of purchasing a practice. We're full service on that front, on the business front, but also we do estate planning because it's equally important for the different dentists and doctors we represent that part is buttoned up. And that's really, we want to be everything you would need, in a law firm for this particular industry. We really specialize in this. So similar to the other presenters in Schwartz & Schwartz, we're very committed to customer service. That is absolutely the unifying thing across the three different groups that are doing this presentation. And, the other thing that we're known for at ESCOW is really clarity on fees, because I know that's a big thing when people are worried about or needing to hire a lawyer. Oh, it's going to be expensive, or I'm not sure what the cost is going to be. And so we simplify that a lot, especially with things like buying and selling a practice. It's a lot of flat fees, so you have a predictable cost. And in that example, we'd actually just take payment at the end of the representation. So we're really trying to be a little bit different than the sort of old law firm that would bill you on an hourly basis for this work. And estate plans are done on a flat fee as well. So we're going to talk about a couple different estate planning tools. You can click the slide. So here are our basic plan tools, right? And so I would say that if you live here in Massachusetts, this is the sort of basic thing we'd start with. And I should note that that trusts bubble on there, there's a variety of different types of trusts. But for our purposes today, the main trust we're going to be focusing on is a revocable living trust. And again, there's other types that we can get into, but that's basically the core estate plan for the average person, even if they're not in this industry. Even if they're younger, and haven't really amassed a lot of assets yet, this is what we would recommend. And here's the different tools that we have. The first is a will. Okay, so that's actually a minor player in the overall estate plan, but it is the thing that everyone thinks of when they think about estate planning or thinking about end of life. And we'll discuss that in more detail. Then, of course, we have trusts, which are the key component of any plan, whether it be basic or very complex. Power of attorney is an important document that allows someone to make legal decisions for you. Healthcare proxy, same thing, appointing someone to make medical decisions for you. HIPAA authorization, which I'm sure a lot of the people calling in will be familiar with HIPAA. This is that list of authorized individuals that can receive medical information. And then something called a living will or advanced care directive, which is a little bit more specific as to end-of-life decisions. So we're going to go through these tools now in more detail. Slide. So the first thing we're going to start with is the will. It has to be written. It's very important to get professional advice, and this applies to all estate planning. There's a lot of there's a lot of online options, and people always say, Sean, are you worried about things like LegalZoom and all these sort of other online items? And I'm not at all, because honestly, we do that litigation component, and a lot of people that have done LegalZoom have had issues with it, and then it causes a lot of fighting later on, and that actually brings in business to the firm. I'd much prefer people do this correct from the start. But if you're looking for a shortcut in this particular area law, there really isn't one. If you were, say, doing a lease, let's say you own some rental property and you needed a standard lease, sure, the Real Estate Bar Association has a basic one online, like that's a form you can get online. The rest of these documents as it relates to estate planning, I strongly encourage you to work with a professional, and I'd take it a step further to say that you should work with someone that specializes in this area. Just as a sort of consumer protection warning, right, public announcement here, a lot of lawyers will say they do estate planning. Maybe they're primarily a business law attorney, and they've got a will or a trust that they kind of have recycled and they cut and paste people's names into. And, from the consumer standpoint, you don't know the difference between a really quality set of documents, key to what you need, and, what else exists out there. And we do a lot of reviews for folks when they've done work with other lawyers. And again, this tends to be sort of an ancillary practice for some attorneys. And for those practices that have done that, we see huge deficiencies, issues, holes, straight things are just incorrect. So it's a really scary area if you don't know what you're doing. And the worst part about it is, when would you discover an issue? Let's say you did a will. When do you think you discover that issue or a trust? It'd be years and years later, right? And so it's this time bomb potentially if it's not done correctly. So, if there's one thing to take away from the presentation, make sure you work with someone that truly specializes in estate planning. And if they have those other areas like the probate and estate litigation I mentioned, and the probate estate administration, that will be sort of an indicator that they are kind of full service on this front. If they just list like wills and trusts, that might be a concern on their website. So again, not trying to scare anyone, but it definitely is an area that requires a lot of expertise, and it is very individualized, and it can have big financial and family consequences. So make sure you're working with someone that really knows what they're doing. All right, so back to the last will and testament. The most basic of documents, it's written, state laws vary on the requirements. It names someone who's, in Massachusetts, we call it a personal representative. Sometimes it's called executor or executrix in other jurisdictions. And that person is responsible for administering your probate estate after you pass away. Wills are also used to identify guardians for minor children. So you would list the people that you would want to step into that role of guardian. You're actually nominating them for the court to then grant them the right to take care of your children, after the parents are either incapacitated or pass away. So we often get younger couples looking for a will to satisfy just that issue. Who would take the kids? And just a point about guardianship, a lot of people, it's not usually the case that there's no one to sort of take on that role. It's quite the opposite. Usually you've got both sets of grandparents that are kind of vying for that, fighting for that position. Because if they've lost their son or daughter, their tie to their family now is going to be that grandchild. So it's a very emotional thing, obviously, when anyone passes away prematurely. But there's often big court battles over who the guardians are actually going to be. Meanwhile, both grandparents probably are well suited. It's just that from each side of the family there'll be these fights. It can be very expensive, obviously very traumatic for the kids are left behind. So identifying a guardian up front is really important, and this can often be a point of contention among spouses as they're trying to decide this. Who's going to be the first set, who's going to be after. But it's a really important conversation to have. Now, besides the things that we've discussed here, and also identifying who's going to receive your property and not letting the state decide, the will has fairly limited utility on its own. So you may go to a planner and you're trying to decide whether or not I need a will or a will and a trust. I would say almost without variation, you also need a basic revocable living trust, and I'll explain why. Some of the differences with wills you see, if they're very short and they're not very detailed, that can cause an option for someone to litigate or challenge it. So length isn't everything, but the more detailed, the better. And we'll go to the next slide and talk about trust, and inherent in that, I'll talk about some of the limitations of just having a will alone. So when we're talking about trust, there's a variety of different types. On the slide here, you see the revocable living trust I mentioned. The ILIT, I-L-I-T, is an irrevocable life insurance trust, real estate trusts, all that. In a general, the trust is a instruction sheet, and it also empowers someone to serve as your trustee to help manage assets for you or your beneficiaries. It definitely simplifies transfers on death, saves a lot of money, and there's a lot of tax planning that can be done. I'll go into more detail about this in a moment. But as far as the difference between just a will and a trust, just having a will is kind of the outdated plan. The modern estate plan includes a will, but the will says I leave everything to my trust. Why would we do that? Limits on the will. It only works at death, right? You have to die. You have to have someone then appointed to be your personal representative. The courts can take a while to do that, so assets can be held up during that time. If you only have a will, all of your assets are going to go through the probate process, which means they'll be tied up in that process for over a year, so you'll have limited access to them. Creditors will be able to make claims on your estate, your probate estate, and when you hire a lawyer to do that work, it's on an hourly basis. So the more assets you have that avoid probate, the lower your legal fees are going to be, because it's going to be a more simple estate to administer under the probate laws here in Massachusetts or other jurisdictions. The other limitation of the will alone is it only deals with death. So what about your assets when you become incapacitated? Well, the trust can take care of that. It really becomes the primary tool that you're going to have all your financial assets, for the most part, keyed to, and you're going to be trustee of your revocable living trust during your life, and then you're also the beneficiary. But if something happens to you, then you're going to have someone else step into that role. So maybe your spouse becomes a successor trustee if you're in the hospital for an extended period of time, and that person will be able to manage the assets for you. The other thing that the trust does is it allows for it to be sort of an extension of your parenting. So most plans take care of the surviving spouse if you're married, and then it has a benefit for the kids. But one thing that you definitely want to be wary of, and you would never get with a will, is what happens if the kids have an issue where they are 18 and they receive all the money at once, right? So without proper planning and sort of a scaled back distribution or distributions over time, they could conceivably receive a big check right at age 18, right? Because they're adults at that age. So what we often do with the trust is, when there's children involved, we have those distributions be over time. The trust will be able to be used for the children's health, education, maintenance, or support throughout their life. But if they need something, that's really what that focuses on. But they're also going to receive distributions at certain ages. So a common scheme will be to provide a third at age 25, a third at 35, and remainder at 40. Or you can do any number of different things, but that allows for sort of a distribution over time, and they get used to managing wealth. You can imagine even the most responsible 18-year-old might make different decisions with an influx of cash than they would at age 25, for example. And age isn't everything, but it's definitely a way to have it be an extension of parenting and really provide for your beneficiaries in a way that you can't if it's just an outright distribution or a specific payout from a life insurance product or something like that, where they'd receive all of the assets at once. There's also inherent in the revocable living trust, there's a lot of tax planning we can do for married couples. So if you're married in Massachusetts, you're going to want to take advantage of that exemption amount, the state exemption amount. And the way that this works functionally is, like it was said, there's no tax owed at the first spouse's death. But if you have this type of a trust plan and you do the simple Q-tip election, so you let the Department of Revenue know that you have this estate plan, you're preserving that exemption. You can actually pass more wealth on to the next generation. So when the second spouse passes, a portion of the estate will go tax-free to the children. And it's through a series of sub-trusts. And I'd be happy to go offline with anyone and dig in a little more on that. But doing a revocable living trust as a married couple is going to save you on state estate taxes. And it's probably your best defense against them, besides gifting over time and just lowering your estate below that $1 million mark. So there's a big component of tax planning to this. The other more advanced trusts, things like the islet there, that would be used to get a life insurance product out of your taxable estate, and that is an irrevocable trust as opposed to one that you can change, the revocable trust. The one I've been primarily focusing on today, you can change at any time. So as your circumstances change, you can change it, and people really enjoy that. And I always say in Massachusetts and other jurisdictions, a basic revocable trust and a prenuptial agreement are probably the best you can do for your money, dealing with a lawyer for the average person. They really are huge cost-saving mechanisms, and pretty much everyone needs them. If you have very low assets, you're not working, you're on public assistance, something like that, you might not need a trust. But, for most people in the Commonwealth that are, have a job and are working, this is going to be a huge tool to save their families money, which is great. As far as the simplified transfer on death, everything that is in this trust avoids the probate process. I mentioned that, but mechanically what that means is that upon that spouse's death, the trustee, usually the survivor spouse, will have full access to the assets, right? And that's going to simplify things greatly, and it also cuts down on the total cost of the plan. You know, I can talk about trust for a long time. This is really the key to estate planning. The basic takeaway I want for everyone here is that you likely need one, and they should talk to an estate planning attorney about it as soon as you can. We can do the next slide. All right, so now we're, you know, more simple document, power of attorney. You know, this is a document that authorizes someone to make legal decisions on your behalf. Oftentimes, those legal decisions manifest in the form of financial decisions. And the durable nature of this type of power of attorney means that it would survive your incapacity. So you can do powers of attorney for anything. You know, if anyone's done a real estate closing, they'll often give either the real estate attorney or maybe like, you know, a spouse or whoever it might be signing for them if they don't want to go to the closing. You know, they give them a limited power of attorney to do that. So you could, you know, it's really just a delegation of something that you have a legal right to make a decision on. You can delegate that. The power of attorneys we do for people in an estate planning context, they're more expansive. The idea here is you're appointing someone to make legal decisions for you, you know, and if you couldn't make them yourself, you know, you want to have it be someone you trust, right? It could be just for convenience. Maybe you're on a trip out of the country and you need a friend or a spouse to move money from your own account into a different account that you own to sort of replenish it. You know, a power of attorney put in place would, you know, effectuate that transfer. You take it to the bank, you know, they'd verify it, they might try and reach out to you, but ultimately it's this delegation of legal authority to make decisions. And we do these usually for almost anyone that walks in the door that doesn't have one, along with the healthcare documents I'm going to talk about in a minute. But at its core, it's something that is, you know, is absolutely needed. And also, this does some of the things that a trustee would be able to do, but ultimately, a lot of banks question the power of attorney, so it's much better to have a trust set up. Next slide, please. So let's talk a little bit about healthcare, and there's really 3 documents when we're talking about that. The first is the healthcare proxy. So this is a document, you know, state statute authorizes action not just on end-of-life wishes, but on all medical decisions. And it doesn't, you know, you're not delegating the power and giving it away. It's really just identifying someone that can make those decisions on your behalf if you can't make them yourself, right? They can be revoked or changed at any time. Oftentimes, hospitals and other medical practices will have you actually, you know, sign a new one when you walk in. When you do one with us, you can easily provide that to the healthcare provider. And this is also something that we actually do on an ongoing basis. So if we do a plan for you, you know, we've had people call in the office frequently and say, hey, you know, Sean, I know you did my mom and dad's will and trust, you know, 2 years ago. We're headed to the hospital right now. Do you have those documents? And we've been able to sort of fax them over quickly or send them by email quickly over to the hospital if they're not already in the medical records, and authorizing the children to make decisions on behalf of, you know, the parents, right? So it's a really important document to have, and it's, you know, the sort of core document when it's under the healthcare decision making that we need to identify not just one person, but a series of people in order to make decisions. And one thing I'll note about this, I see this a lot, and it's not great. Casual planners, we'll call them, will just put whatever the client says. You know, oh, you want these 2 children being the proxy jointly? All right, well, what are you going to do about a tiebreaker, right? You know, doctors don't like dealing with a committee. So, you know, the sort of advice that comes in with our practice is really helpful to say, look, you should really just have one and then have a secondary or a third or a fourth. And so that's something that's important to note when doing these documents. Next slide. HIPAA authorization. So, of course, the federal privacy law for medical records, which I'm sure you're all familiar with. You know, we have a specific separate HIPAA authorization sheet that people fill out, and this is a list of people that are authorized to receive medical information. We often describe it, you know, generally as the document that lets, you know, your uncle or your friend or your, you know, whoever call in the hospital and see how you're doing. And so it's a really important document to have in place. And we do it as a separate document because we think that this list tends to be more expansive. It's not usually the same people that are the authorized decision makers under the healthcare proxy. So we don't want this larger list of individuals, friends, family, whoever, to sort of know who the decision makers are on the healthcare proxy side or the order, right? So we keep this separate. I do see a lot of attorneys kind of smash this together, you know, all 3 of these documents together, and I think it's just laziness. It's not really helpful to do that. Next slide. So, the additional document that is not legally binding in Massachusetts, but is very helpful for healthcare professionals, is a living will or advance directive. And the living will name is kind of funny because it's not a will, and yeah, you create it while you're living, but really it's a guidance document for end-of-life care and care generally, but specifically for end-of-life care. And this is a document that you write out your wishes. It's state law varies widely on this. Like I mentioned, in Massachusetts, it's not legally binding, so you couldn't take someone to court because they failed to pull the plug, even if that was in the document as a desire. But it's also something where you as a healthcare agent in Mass can act without being worried about getting sued for not doing that. So it's actually, I think, a good balance. Other states make them legally binding, but it is an important document to have to be able to provide guidance. Now, the other reason why we focus on this, and a lot of lawyers will kind of breeze through this, we have a big focus on it, not only because we work with a lot of healthcare professionals, but it's really important to our clients. What we commonly see with low-level planners is some document where it says the client doesn't want the healthcare agent to take any extraordinary measures. Well, that's really not that helpful, right? What does that really mean? So we drill down a little bit more. We get very specific. Because there's no statute on this, you can really customize it to any way you want, with the emphasis on imparting on the healthcare agent what you would want in certain circumstances. So, ours has a portion about whether or not you'd want antibiotics administered, whether or not you're open to, novel or new or experimental surgeries or medicine, whether or not you'd prefer to stay in your home rather than a hospital if it didn't sacrifice your care. And all of these sort of critical decisions are premised by the fact that you're unconscious and there's no reasonable likelihood you're going to be conscious again. And so once you clear that hurdle, people are pretty comfortable putting down that they don't want to be resuscitated, or they don't want to have a breathing tube, inserted down their throat. Some people will, key it to a certain amount of time. I'm okay with life support for 60 or 120 days and then pull the plug. But what everyone's hoping to avoid with this is this sort of, state where you would live for years without any really ability. You could be brain dead, but legally in Massachusetts, it's not a right to die state, so you couldn't impart your wishes that you'd want to actually die in that case. You just have to sort of limit the care that you receive, and then you possibly pass away. The image on here is, of course, the famous case of Terry Schreibo from the 90s or 2000s rather. She was in this persistent vegetative state for many years, and there was a huge legal battle over, whether or not to remove a feeding tube, okay, with the husband versus the parents. Huge case, definitely something that you don't want to have to deal with. And that's the nature of all this work, right? No one wants to sit around on a Friday night with a glass of wine, enjoying time with their spouse and say, all right, if I'm in a coma, this is what I want you to do or not do, right? So because that's not a common conversation, but because it's very helpful to know, we do that as part of the planning now. And the planning we do now will make that decision so much easier for the decision maker later. You won't have to guess about what your spouse or your brother or whoever you're the agent for would have wanted. It's down on the page. Even if you had that conversation, it being written on the page really is a statement of their wishes and alleviates a lot of the moral liability from having to make that decision. So again, a document that's often breezed by I'll say, less detailed planners. We focus on it a lot because it's very important to our clients that they are able to sort of make that statement as to their end-of-life wishes. Slide.
Okay. Well, I'm going to take back over here, and I just want to emphasize again, thank you, Sean, for doing those few slides there and really laying the groundwork. I think you could tell from hearing Sean speak about these issues that he's certainly seen this done right and seen this done terribly, terribly wrong. And as you're going through your consultation with him, I'm sure he has many stories that he can tell you on every aspect of this that will help you to avoid, just a lot of unforeseen blind spots that you just haven't thought about until you actually start to go through this process. So hopefully that little bit helped, but certainly a further conversation will do even more work. And so,
yeah, the other thing I should mention is just that I'm available to anyone that's listening to this. They can email me at Sean, S-E-A-N, @escalawgroup.com. And I truly mean, if you have a question about this, I'm happy to field it. I'm on a mission to make sure people know about these documents, the basics at least. And I'd be happy to answer any questions or take a phone call. You can find me online as well. Thank you so much.
Yeah, awesome. Thank you, Sean. And we're just going to close here with a couple more slides because I'm going to bring it back as far as what we can do to take control. Certainly many of these issues that we've talked about, you will need to meet with an estate attorney and get these documents drawn up and go through these various decisions. But I just want to talk about gifting really quickly because I think this is a spot that many people forget, that they can actually start to pass assets to their heirs now as opposed to simply when they pass away. So from a legal standpoint, we've talked about the federal estate tax, the state estate tax, and how much you can leave. I just want to make sure I bring up also that you're allowed to pass up to $15,000 per year to whomever you want. It could be your children, obviously, but it could be a nephew or niece, and then obviously charitable contributions are unlimited. But the reason that this is so important is as you're starting to decide how is my estate plan going to look, I like the idea of benefiting those recipients now and seeing what they're going to do with those funds as they receive them. As Sean mentioned, some may want to set up a trust that gives a third at age 25 and gives a third at age 35. Well, if you're no longer there to manage the money and they get that at 25 and they just go to Las Vegas and blow the money and they don't do anything good with that, are you going to be as happy to let them have the next third at age 35? Probably not. But while you're living, you can start to make these gifts and start to actually take more of a mentorship role in their lives to make sure that they know what to do with this money. Maybe they should start up a Roth IRA. Maybe they should put more to their company 401k account. Maybe they should start to get their own estate planning or life insurance in place that maybe was cost prohibitive to them before. So, I really would encourage, those that may be, getting into retirement and starting to think about an estate plan to start taking control of that now. I think where I've seen this done wrong on my end, some people will want to set up a trust that says, well, I'll leave them the money if they get a certain GPA. If they go to college and they get over a 3.0, that's when they'll be able to get their money. Well, that sounds good, but may have unintended consequences. So, if I'm going to be the recipient of that money, let's say I'm that child, and I can go to, let's just say, Harvard or UMass Amherst, and I know I'm going to get a lot of money if I get a 3.0, maybe I'm more willing to go to UMass Amherst at that point in time and get that 3.0 GPA. It's just going to change my decision-making just a little bit just because of that provision. So, that I just wouldn't really necessarily recommend. I've seen other trusts where they say you have to be in a certain profession, like you have to be a teacher in order to get this certain amount of money. Again, things I would encourage you to avoid and maybe start to have these conversations and thoughts during life. Okay, so this has the added benefit of moving your assets out of your estate. I will also mention that I say $15,000 per year, but that's per person. So if you're married, you can actually start to give $30,000 away to one individual. In fact, you can actually also do a 5-year forward averaging if we're using this for educational purposes. So I see a lot of people who are starting their estate plan. They might put $75,000 immediately into a college 529 plan because, again, on a 5-year forward averaging, you can't gift for those 5 years, but you'll essentially load them up in year one to move assets out of your estate. One final note on this will be that not only can you give $15,000 per year, but you can give an unlimited amount if you're paying for somebody's college tuition on their behalf. So if you make the check directly to Harvard or directly to UMass Amherst, that does not count in this annual gift exclusion or your lifetime exemption. So that's a great idea to think about how you might get assets out of your estate. And then finally, medical bills. Also, if you're paying for them on behalf of your child, paying the hospital directly will not lower your exemption amount and will not violate this annual exclusion amount. So many more options to think about during life to take a little bit more control of your assets. Okay. So, just to wrap us up here, I think there are just many thoughts that you're going to want to have as far as taking action on your plan. Certainly seeing Sean for estate planning documents, looking at different kinds of insurance to ensure that you can provide an inheritance or can provide a business buyout, as we've talked about, earlier, making sure liability limits are in place with things like an umbrella policy. That might be another blind spot that you haven't thought about before. And so, finally, I would say as you go through this process, it doesn't necessarily end with making the estate plan, but also requires you to communicate to your heirs what's going to happen. And certainly both Sean and I can give advice on how you might go about that. But the more that you're communicating with them, the better off you're going to be. That way, when you become incapacitated or when you pass away, there isn't an argument with your family members because they might be seeing these documents for the first time, or it may take them a long time to actually locate these documents because maybe they don't know who your advisor or estate attorney is. They can know that well in advance and know what your wishes are, just to make this as smooth as possible. Again, I've seen this done well, where everybody is on the same page, and in a time of grieving, you don't have this added stress of figuring out what's going to happen. And then I've certainly seen it done wrong, where there's a lot of arguing and fighting, and really, can ruin relationships for life between a brother or sister that just simply aren't on the same page. So I just want to make sure I emphasize that. Putting your documents in a place where people know they are, having many copies of them. I've even seen people put these documents, if they're in an elderly state, right on their refrigerator. So that way, if an emergency contact comes in, they know right where they are, and there's no confusion as to what's going to happen. So make sure you're thinking about that. And then finally, certainly thereafter, keeping an idea as to what might be changing both on the legal side, but then also in your personal tax situation, your personal life situation and family situation. We want to make sure we're reviewing these every few years. And as Sean mentioned earlier, he certainly has many of those clients coming back to them to make changes, especially since on these revocable trusts, they're certainly flexible to be changed over time. And certainly he'll contact you proactively if there's a big change that he thinks that needs to be done. Okay, so that wraps up our seminar today. Again, our website here for First National Corporation, fncadvisor.com. We do put out a weekly newsletter that goes over what's happening with the investment markets, but also covers various topics like the ones we've done today, where we write a blog post and maybe discuss some of this that you can get right emailed to you. You certainly can unsubscribe at any time if they can't become a little too overwhelming. And then I'll just leave here with our final contact information, our blog, my LinkedIn here, and then both mine and Sean's email and First National Corporation's phone number that you can reach out to us. So again, I thank you for joining us today. Please reach out if you do have any questions, and enjoy the rest of your day. Thank you.